Rule 35, post-conviction remedies. Rule 35. It's 3 pages long, so buckle up. A. Correction of a legal sentence. The court may correct a sentence that was not authorized by law or that was imposed without jurisdiction at any time, and may correct a sentence imposed in an illegal manner within the time provided herein for the reduction of sentence. B. Reduction of sentence. The court may reduce the sentence provided that a motion for reduction of sentence is filed 1. Within 126 days, 18 weeks after the sentence is imposed, or 2. Within 126 days, 18 weeks after receipt by the court of a remediator, issued upon affirmance of the judgment, or sentence or dismissal of the appeal, or 3. Within 126 days, 18 weeks after entry of any order or judgment on the appellate court denying review or having the effect of upholding a judgment of conviction or sentence, or 4. At any time pursuant to a limited remand ordered by an appellate court in its discretion during the pendency of a direct appeal, the court may, after considering the motion and supporting documents, if any, deny the motion without a hearing. The court may reduce a sentence on its own initiative without any of the above periods of time. Other remedies. C. Other remedies. 1. If, prior to filing for relief pursuant to this paragraph 1, a person has sought appeal of a conviction within the time prescribed therefor, and if judgment on that conviction has not then been affirmed upon appeal, that person may file an application for post-conviction review upon the ground that there has been a significant change in the law applied to the applicant's conviction or sentence, allowing, in the interest of justice, retroactive application of the changed legal standard. 2. Notwithstanding the fact that no review of a conviction of crime was sought by appeal within the time prescribed therefor, or that a judgment of conviction was affirmed upon appeal, every person convicted of a crime is entitled as a matter of right to make application for post-conviction review upon the grounds hereinafter set forth. Such an application for post-conviction review must, in good faith, allege one or more of the following grounds to justify a hearing thereon. I. Roman numeral I. That the conviction was obtained or sentence imposed in violation of the Constitution or laws of the United States or the Constitution or laws of this state. 2. That the applicant was convicted under a statute that is in violation of the Constitution of the United States or the Constitution of this state, or that the conduct for which the applicant was prosecuted is constitutionally protected. 3. That the court rendering judgment was without jurisdiction over the person of the applicant or the subject matter. 4. Repealed. 5. That there exists evidence of material facts not theretofore presented and heard, which by the exercise of reasonable diligence could not have been known to or learned by the defendant or his attorney prior to the submission of the issues to the court or jury, and which requires vacation of the conviction or sentence in the interest of justice. 6. Any grounds otherwise properly the basis for collateral attack upon a criminal judgment, or 7. That the sentence imposed has been fully served, or that there has been unlawful revocation of parole, probation, or conditional release. 3. One who is aggrieved and claiming either a right to be released or to have a judgment of conviction set aside on one or more of the grounds enumerated in Section C2 of this rule may file a motion in the court which imposes the sentence to vacate, set aside, or correct the sentence, or to make such order as necessary to correct a violation of his constitutional rights. The following procedures shall apply to the filing and hearing of such motions. 1. Roman numeral 1. Any motion filed outside of the time limit set forth in CRS 16.5.402, 6 CRS, shall allege facts which, if true, would establish one of the exceptions listed in Section CRS Section 16.5.402, 2, 6 CRS. 2. Any motion any goddamn motion filed shall substantially comply with the format of Form 4 and shall substantially contain the information identified in Form 4. Petition for conviction relief pursuant to CRCP 35C. CRCP 35C. See Appendix to Chapter 29. 3. If a motion fails to comply with subsection 2, the court shall return to the defense a copy of the document filed along with a blank copy of Form 4 and direct that a motion in substantial compliance with the form be filed within 49 days. 4. The court shall promptly review all motions that substantially comply with Form 4 petition for post-conviction relief pursuant to CRCP 35C. CRCP 35C. In conducting this review, the court should consider, among other things, whether the motion is timely pursuant to CRS Section 16.5.402, whether it fails to state adequate factual or legal grounds for relief, whether it states legal grounds for relief that are not meritorious, whether it states factual grounds that, even if true, do not entitle the party to relief, and whether it states factual grounds that, if true, entitle the party to relief, but the files and records of the case show to the satisfaction of the court that the factual allegations are untrue. If the motion and the files and record of the case show to the satisfaction of the court that the defendant is not entitled to relief, the court shall enter written findings of fact and conclusions of law in denying the motion. The court shall complete its review within 63 days, 9 weeks of filing, or set a new date for completing its review and notify the parties of that date. 5. If the court does not deny the motion under 4, Roman numeral 4 above, the court shall cause a complete copy of said motion to be served on the prosecuting attorney if one has not yet been served by counsel for the defendant. If the defendant has requested counsel be appointed in the motion, the court shall cause a complete copy of said motion to be served on the public defender. Within 49 days, the public defender shall respond as to whether the public defender's office intends to enter on behalf of the defendant pursuant to CRS Section 21-1-104-1B, 104-1B, 6 CRS. In such response, the public defender shall identify whether any conflict exists, request any additional time needed to investigate, and add any claims the public defender finds to have arguable merit. Upon receipt of the response of the public defender, or immediately if no counsel was requested by the defendant, or if the defendant already has counsel, the court shall direct the prosecution to respond to the defendant's claims or request additional time to respond within 35 days, and the defendant to reply to the prosecution's response within 21 days. The prosecution has no duty to respond until so directed by the court. Thereafter, the court shall grant a prompt hearing on the motion unless, based on the pleadings, the court finds that it is appropriate to enter a ruling containing written findings of fact and conclusions of law. At the hearing, the court shall take whatever evidence is necessary for the disposition of the motion. The court shall enter written or oral findings, either granting or denying relief, within 63 days. 9 weeks of the conclusion of the hearing will provide the parties a notice of the date by which the ruling will be issued. If the court finds that the defendant is entitled to post-conviction relief, the court shall make such orders as may appear appropriate to restore a right which was violated, such as vacating and setting aside the judgment, imposing a new sentence, granting a new trial, or discharging the defendant. The court may stay its order for discharge of the defendant pending appellate court review of the order. If the court orders a new trial and there are witnesses who have died or otherwise become unavailable, the transcript of testimony of such witnesses at the trial which resulted in the vacated sentence may be used at the new trial. 6. The court shall deny any claim that was raised and resolved in a prior appeal or post-conviction proceeding on behalf of the same defendant, except the following. A. Any claim based on evidence that could not have been discovered previously through the exercise of due diligence. B, any claim based on a new rule of constitutional law that was previously unavailable if that rule has been applied retroactively by the United States Supreme Court or Colorado appellate courts. 7, Roman numeral 7, VII. The court shall deny any claim that could have been presented in an appeal previously brought or post-conviction proceeding previously brought except the following. A, any claim based on events that occurred after initiation of the defendant's prior appeal or post-conviction proceeding. B, any claim based on evidence that could not have been discovered previously through the exercise of due diligence. C, any claim based on a new rule of constitutional law that was previously unavailable if that rule should be applied retroactively to cases on collateral review. D, any claim that the sentencing court lacked subject matter jurisdiction. E, any claim, any goddamn claim, where an objective factor external to the defense and not attributable to the defendant made raising the claim impracticable. 8, Roman numeral 8, notwithstanding Roman numeral 7 above, the court shall not deny a post-conviction claim of ineffective assistance of trial counsel on the ground that all or part of the claim could have been raised on direct appeal. 9, Roman numeral 9, IX. The order of the trial court granting or denying the motion is a final order reviewable on appeal. Colorado Rule Criminal Procedure 35. And there's no committee notes. And that's it. That's it. If someone tried to tell you that Roman numeral 7, the court shall deny any claim that could have been presented in appeal previously brought or post-conviction proceeding previously brought except the following, if anybody tells you that, then they give a shit about your mind and they want you to know about Colorado law. And they want you to know all of Colorado law. A, B, C, D, E, and F. And all of the Roman numerals listed under Section 3, which is listed under Section C. So Rule 35 has A, B, and C. A, B, and C. And that's it. Pretty sure. A, B, and C, and that's all they got. A, correction of illegal sentence. B, reduction of sentence. And C, other remedies. Other remedies. Other remedies.